Lana, je donne la parole maintenant à Maître Sakuchi.
Mr. President, distinguished members of the Court, the hearing on this case comes to a time when guidance is urgently required from this Court as to what is not permissible so far as the control of sea migrants' flows is concerned. As my learned friend already pointed out, the main question to which this Court is called upon to give an answer in the present case is whether the applicants' pushback to Libya after their interception by an Italian vessel on high seas contravenes the guarantees enshrined in Article 3 and 13 of the Convention and in Article 4 of Protocol Number 4. And on this question, I will focus my further brief consideration. However, I must first of all respectfully emphasize that the Court's decision on this case clearly transcends the persons and interests of the applicants. Indeed, the matter under consideration raises a question of general importance for the European public order, which should be ruled in the collective interest of the community of the contracting states. The resort to pushback operation as a general policy instrument aimed at stopping the flowing of sea migrants from Libya has immediately generated a considerable alarm in the European space of fundamental rights. For this reason, although the primary purpose of this application remains that of providing adequate relief to individual victims, and in particular to those among the applicants who are still alive, the Court's mission is also to determine issues on public policy grounds, thereby raising the general standards of protection of human rights with respect to maritime interceptions operations and the processing of international protection claims. The main allegation of the applicants is that by pushing them back to Libya, the Italian authorities have knowingly returned them to a country where there were substantial grounds for believing that they could be subjected to torture or other inhuman or degrading treatment in breach of the absolute prohibition laid down in Article 3. Notably, the applicants had reasonable and objective grounds to fear first that they would be exposed to ill treatment in Libya, and secondly, that they would be at risk of being deported to their home countries where they faced persecutions in conditions that would moreover put their life in serious jeopardy. The question this Court is called upon to decide on Article 3 is therefore twofold. First of all, was there a real risk for the applicants of being subjected to ill treatment in Libya? Secondly, was there a real risk for the applicants of being subjected to such treatment in their home countries without enjoying in Libya a sufficient degree of protection against refoulement? Yes, the answer to both questions by qualified governmental and non-governmental international human rights actors to both questions was an absolute and unconditional yes. No single voice rose to the contrary. No contracting party openly supported the Italian government's action, and even non-contracting states that in the past had resorted to similar practice of interdiction of sea migrants have expressed criticism about the Italian pushback operations. And I'm referring to the 2010 country report on human rights of the U.S. State Department, which was released just a few months ago. The Court certainly does not ignore the conclusions reached by the CPT in its report on the pushback operations, where it stated that, and I quote, "there would appear to be a real risk that persons detained in Libya, including migrants, may be subjected to severe ill treatment and or be sent to a country where they are at risk of such treatment." These conclusions and the accurate assessment of facts on which they are grounded would themselves be sufficient to relieve the applicants from the burden of convincingly proving this Court the well-foundedness of their fear for Article 3 purposes. Be as it may, in our written submissions, we have extensively addressed the issue of whether there were substantial grounds, and since we have been instructed by the President not to replicate orally our written submissions, I will respectfully leave that issue to the judge's reading. Nonetheless, it is important, in my view, to emphasize two key aspects of the case that should be kept in mind when ruling on the compatibility of the pushback operation with the principle of non-refoulement. The first one concerns the criteria to be applied for assessing the risk on Article 3. Indeed, the application under your consideration today falls within the kind of cases where the risk of prohibited treatment originates from a general situation in the receiving country. Since its judgments in Saadi versus Italy and in NA versus United Kingdom, this court has stressed that in cases where an applicant is a member of a group systematically exposed to a practice of ill treatment, the protection of Article 3 enters into play when the applicant establishes that there are serious reasons to believe in the existence of the practice in question. While the applicants do belong to a group, that of African asylum seekers of Somali or Eritrean origin, illegally crossing the Libyan borders with a view to reach the European continent, a group that is systematically exposed in Libya to a practice of ill treatment, including refoulement and other serious human rights violations. The second key aspect of the case concerns the sources of information available for establishing the existence in Libya of such a practice. According to the case law of this court, the risk of ill treatment should be assessed having regard to the circumstances that the state knew or ought to have known at the time of the expulsions. And in this context, the court relied on information contained in recent reports from independent international human rights associations as well as on governmental sources. While as compared to other cases where this court has found a breach of Article 3 in relation to a general situation in the receiving country, the present case stands out for the quantity and quality of the information available on the treatment of undocumented migrants and refugees in Libya, which is greater than ever. In addition to the report of the CPT I mentioned before, particular weight should be attached to the outstanding amount of reports, documents, materials submitted by Human Rights Watch, Amnesty International, the International Federation on Human Rights, and the ARES Center in their amicus curiae briefs, many of which based on field surveys, as well as to the information contained in the U.S. State Department country reports on human rights practices. The majority of the sources were publicly available and widely disseminated at the time when the pushback operations complained of took place. All the said sources indicated that African illegal migrants in general and asylum seekers from Somalia and Eritrea in particular were indiscriminately and systematically subjected to ill treatment, arbitrary detention, life threats, sexual violence, collective expulsions, and other serious abuses by Libyan authorities, and that there was no adequate legal protection scheme in place for those who feared persecution in case of deportation. Unfortunately, in the applicant's case, the risk of ill treatment did not remain merely potential. As my colleague has already told you, immediately after the disembarkment in Tripoli, the applicants were in fact subjected to all sorts of violence and abuses, as they reported us by email and telephone. The stories of Ermias Burane and Segai Hattem are of particular importance in this respect. In other words, the applicant did not only risk ill treatment, they had in fact been ill treated. Against this background, The Italian government is standing before this court today with no shame, pretending us to believe that Libya should have been considered, or perhaps should still be considered, a safe place for Article 3 purposes. In other words, the Italian government pretends us to believe that they ignored in good faith what was crystal clear to anyone else in the world. And they just realized a few months ago that the Libyan regime was responsible for large-scale human rights violations of such gravity to justify a military intervention. In a matter of days, the safe place was turned into a warfare, where the applicant's life was mockingly exposed to a further unexpected risk, that of perishing under the friendly bombs delivered by the coalition air forces. Concerning the risk of persecution the applicant would face if deported from Libya to their home countries, this court has recently reiterated in MSS that indirect removal to an intermediary country may engage the responsibility of the contracting state under Article 3, and that the contracting state must make sure, and I quote, that the intermediary country's asylum procedure affords sufficient guarantees to avoid an asylum seeker being removed to his country of origin without any evaluation of the risk of prohibited treatment. In the present case, the existence of the risk of ill treatment in case of deportation to Somalia or Eritrea is irrefutably proven by the fact that the majority of the applicants have been granted refugee status by the United Nations High Commissioner for Refugees shortly after they returned to Libya. We have provided detailed information on this aspect in our written submissions. It follows that, in the absence of effective protection against refoulement in Libya, the applicants pushed back to that country have certainly impinged on their Article 3 right not to be exposed to indirect removal to non-safe countries. Being left without any other valuable argument to justify its conduct, the Italian government sought to rely in its observations on a very simple denial. None of the applicants would have actually requested asylum to the officials on board. I will deal a bit further with this issue when addressing the applicant's complaint under Article 13. However, it should be stressed straight away that, as recognized by the CPT, the absence of explicit request for asylum does not necessarily absolve the Italian authorities of their non-refoulement obligation, especially when, and I quote, the circumstances are such that the persons concerned are not in a position to express such a request. And this would be certainly the case of persons surviving a sea voyage. Indeed, the protection afforded by Article 3 also entails a procedural requirement which is of absolute importance to ensure that eligible persons are properly informed about the opportunity to claim international protection against refoulement to a given country. Now, in the present case, it is undisputed that the applicants have not been informed at all about their final destination or about the possibility to claim protection while on Italian vessel. It is likewise undisputed that the applicants were not even identified formally, let alone given access to linguistic assistance on board. Therefore, the government's contention that they did not request asylum is patently malicious, as should be firmly rejected as abusive. As far as the right to an effective remedy is concerned, the Italian authorities have patently failed to secure such right in conformity with Article 13. Notably, the applicants had no effective access to any sort of remedy or procedure before a competent authority for claiming their Article 3 right not to be removed to a non-safe country. According to the case law of this court, the effectiveness of a remedy in cases of expulsions imperatively requires independent and rigorous scrutiny by a national authority of any claimed risk of torture and access to a remedy with automatic suspensive effect. As already explained by my colleague, none of these basic requirements have been fulfilled in the present case, where the applicant's claims for protection simply remained unheard, and no measure was taken in order to prevent them from being exposed to the risk of ill-treatment. In any case, the respondent government acknowledged in its observations that the right to an effective remedy, and I quote, could not be guaranteed on vessels in the circumstances indicated above, paragraph 49 of the respondent's observations. This is a crucial problem. Even assuming that the applicants had in abstracto the right to claim asylum on the vessel, and that they were given in concreto the possibility to exercise such right, which is not the case, they will still be deprived of the procedural protection afforded to asylum seekers by the relevant domestic legislation. For instance, they would not be entitled to challenge before a court the refusal to accept their claim by the vessel's officials. In more general terms, it should be emphasized that pushback operations are not regulated by law. There is no ad hoc protocol that could be applied for the processing of protection claims submitted on the Italian vessels performing such operations. By simply pushing the line of its border control operations off the territorial waters, the Italian government sought to create a no-rights zone where they pretend to be relieved from their obligation under the Convention. This court should prevent the contracting states from creating such Guantanamos on high seas where mixed migration flows are treated indiscriminately without the possibility of having access to the guarantees provided for by domestic European and international law. Concerning the alleged violation of the prohibition of collective expulsion, the respondent government, I conclude. I will then maybe respectfully reserve the opportunity to develop some further consideration in my reply. Thank you, Mr. President.
Thank you very much, Mr. Seccucci. Je vais